Hello everyone. Ang ating discussion in our today's session is all about general principles of contract. And to start with, let us have our introduction. Every now and then, contract serves as a very important role in business. It gives protection and responsibilities for both parties to serve and give a particular good or service to another party in exchange of money or another service. Gaining background on contract gives knowledge to exercise our rights and currents. Let us now define contract. It is actually a document between two contracting parties which take place when an offer by one party is accepted by other. The client and the contractor is one example. Contract law is based on the principle expressed in the Latin phrase pacta sunt servanda, which is usually translated agreements to be kept, but more literally means pacts must be kept. And for the continuation of our introduction, again, the term contract can be defined as an agreement between two or more parties that creates obligations enforceable by law. A contract is created anytime things of value are exchanged. Contract law was developed to support and enforce promises that make people in reliance on the promises or acts of others. Now let us have the importance of contract. To define inclusion terms and condition of the bond. Another importance is to give a specific material list, quality material, and deadline. To enable the contractor to have obligation in a certain project. And to assure the owner against loss resulting from the failure of the contractor to complete the work in accordance with the contract. Guarantee payment of bills or all bills by the contractor for labor and materials. Let us have now the principles of contract. For a contract to be valid, both parties must give their consent. Kailangan parehong amenable ang magkaibang panig. They must act in such a way that the other people involved believe their intention is to make a contract. Thus, a person who is clearly not sincere in saying that he or she accepts an offer usually is not held to a contract by the courts. Consent is manifested by the meeting of the offer and the acceptance upon the thing and the cause which are to constitute the contract. The offer must be certain and the acceptance absolute. A qualified acceptance constitutes a counter offer. On the other hand, a person who secretly has no intention of making a contract, but who acts in a manner that leads people to believe he or she had, may be held to a contract. Legally, it is the external appearance that determines whether one is held to a contract. Let us have the word offer. It is actually a proposal made by one party to another to enter into a contract. Or in other words, it is a proposal. Offer can be an offer of service or good and everything else that matter. It is also a promise to act or to abstain from acting on condition that the terms thereof are accepted by the person or the offeree to whom it is made. Example 1. An offer to buy a car from B for 2 million pesos, clearly in this statement, is an offer. For the most part, the offer will be along the lines of someone promising to do something, buy something, or give up something. Then, offer must be certain also. The offer must be certain or definite so that the liability of the parties may be exactly fixed because it is necessary that the acceptance be identical with the offer to create a contract. About acceptance, it is actually a manifestation by the offeree of his assent to the terms of the offer. Without acceptance, there can be no meeting of the minds between the parties. The acceptance regarding the above scenarios would be B's reply, yes, I will sell you my car for 2 million pesos. A counteroffer will not act as an acceptance, but rather as a rejection. Referring to the above scenarios, B says, I will sell you my car for 2.3 million pesos instead of $1,000. This is a rejection of the initial offer and becomes a counteroffer to A. A must now choose to accept or reject B's counteroffer. If A rejects the counteroffer, the original offer is no longer on the table. The process begins again. For the acceptance of offer must be absolute. The acceptance of an offer must be absolute or unqualified. It must be identical in all respects with that of the offer so as to produce consent or meeting of the minds. If the acceptance is qualified, as when it is subject to a condition, it merely constitutes a counteroffer within law, which in law is considered a rejection of the original offer and an attempt by the parties to enter into a contract on a different basis. A qualified acceptance must, in turn, be accepted absolutely in order that there will be no contract. About consideration. It is something of value given by a promisor to a promisee in exchange for something of value given by a promisee to a promisor. Typically, the thing of value is an act, such as making a payment or a forbearance to act when one is privileged to do so, such as an adult refraining from smoking. Consideration means that something of value must be exchanged. The consideration in the car scenario for A would be receiving the car. The consideration for B would be receiving the 2 million pesos considering or consideration in a contract must be mutual. That is, both parties must receive something of value. The value need not be equal or necessarily fair. A can offer to buy B's new Chevrolet Suburban 4x2 for 2 million pesos. If B accepts, then a contract will be made. Even though it should be obvious that this is not a fair deal, that sums up basic contract principles. Consideration consists of a legal detriment and a bargain. A legal detriment is a promise to do something or refrain from doing something that you have the legal right to do or actually doing or refraining from doing something that you doesn't have to do. A bargain is something the promisor, the party making promise or offer, wants, usually being one of the legal detriments. The legal detriment and bargain principles come together in consideration and create an exchange relationship where both parties agree to exchange something that the other wishes to have. The purpose of consideration is to ensure that there is a present bargain, that the promises of the parties are reciprocally induced. The classic theory of consideration required that the promise be of detriment to the promisor or benefit to the promisee. This is no longer the case. Intention to create legal relationship. If a promise is to be enforceable, it must be shown that it was intended to be a legally binding commitment. This excludes merely domestic arrangements such as promises to pay pocket money or housekeeping money, for these are to be enforced in the kitchen rather than the courtroom. In contrast, agreements of a commercial nature are presumed by the courts to be entered with the intention of creating a legal, enforceable relationship. Contrary to the commonly held belief, this does not necessarily mean that there is no contractual relationship between them. So long as the terms of the relationship are sufficiently clear, the court would not hesitate to find that the parties had intended to enter a legal and therefore enforceable contract. If the court's jurisdiction is to be excluded, very particular proof of the intention is required. Content of the contract. Not everything in a contract is necessarily a term of the contract. Some matters are classified as mere representations and are not enforceable. For example, if a person says, I will sell you very fine ang Kyoko painting for 100,000 pesos, the phrase very fine would not be considered a term of the contract. Rather, it would be treated as a promotional fop. On the other hand, the fact that the painting was made by ang Kyoko and that the price was 100,000 pesos would be treated as terms of agreement. It is not always easy to distinguish between terms, mere representations, but one may ask oneself, would it appear to be reasonable onlooker that the party was guaranteeing the truth of the statement? If the answer is yes, the statement is a term of the contract. The most important types of term are conditions and warranties. Naming them is easy, but accurately describing them is not. For centuries, judges have battled as it may be. The problem is an important one because the breach of condition permits the disappointed party to rescind the contract, whereas the breach of a warranty only permits the party to sue for damages to make up for any loss that have been suffered. Another example of the content of the contract, we have the conditions of the contract, and of course, the warranty contract right after finishing or accomplishing the said project or construction project. Let's talk about the competence. Both parties must be competent for a contract to be enforceable. A contract with a person who has been educated insane is likely to be declared void. A contract involving a minor, a person under 18 may be enforced or voided by the minor, unless the contract is for necessities such as food, lodging, or medical services, in which case he or she may be held responsible for the reasonable value of what was purchased. Persons suffering from disabilities such as intoxication from drugs or liquor, for instance, persons not educated and sane, usually may void the contract if the party knows or should have known of the disability and if the consideration received is returnable. Let's talk about legality. Whether the contract is for services or for the sale of goods, the contract may be either wholly oral, wholly in writing, or partly in writing and partly oral. Its form is not relevant to validity. Some memorandum in writing of the contract is made and signed by the party to be charged or the buyer accepts some of the goods in part performance of the contract, or the buyer gives something in earnest to bind the contract or in partial payment. If a proposed contract requires an illegal act, the result is a void contract. Parties to an illegal contract have no standing in court. If one party receives some money or property under an illegal contract, the other may not sue to recover what was paid under the contract. Not only are contracts requiring criminal acts illegal, so are contracts requiring commission of a tort, a breach of civil law such as misinterpretation or trespass, or those in breach of public policy. Although public policy is difficult to define, it includes some serious breaches of conventional morality or ethics. It is commonly assumed that an enforceable contract must be in writing. This is usually untrue. Most oral contracts are enforceable, but written contracts are easier to prove. Some types of contracts must be in writing. For example, contracts for the purchase or sale of any interest in real property, contracts to pay debts or others, and contracts that require more than a year to perform. Although only a few types of contract must be in writing, the terms of a written contract ordinarily may not be contradicted in court by oral testimony. Avoiding contract or contractual responsibilities. At common law, a number of factors may vitiate a contract. They include duress, mistake, legal incapacity, deceit, misinterpretation, illegality, and undue influence. Remedies for the breach of contract. In the event of a breach of a contract, the injured party usually sues for money damages. Damages are measured by what reasonably be foreseen as financial losses. Unforeseeable losses may not be collected. If an award of money is not compensatory because something about the firm's performance was unique, the party who breaks a contract may be ordered by the court to perform as agreed. This is called the specific performance. For example, real estate is always considered unique. Therefore, when a party has contracted to sell real estate but changes his or her mind, the court may grant a specific performance and order that the deed for the real estate be delivered to the agreed buyer. Most contracts are formed with an implicit understanding that neither party need perform unless the other has completed his or her promised performance. An exception to this understanding occurs when a party has performed most of his or her obligation and the part not performed is relatively immaterial. The doctrine of a substantial performance provides that in such a case, the opposite party must perform, although he or she may secure money damages to the extent that he or she was damaged by lack of complete performance. Unilateral and bilateral contracts. Let us start first with the unilateral contract. It is an agreement when an offer can be accepted only by the offeree's performance. In a unilateral or one-sided contract, one party, known as the offeror, makes a promise in exchange for an act by another party, known as the offeree. If the offeree acts on the offerer's promise, the offerer is legally obligated to fulfill the contract, but an offeree cannot be forced to act because no return promise has been made to the offerer. After an offeree has performed, only one enforceable promise exists, that of the offerer. Reward offers are usually unilateral contracts. The offerer cannot impel anyone to fulfill the reward offer. An offeree can sue for breach of contract, however, if the offerer does not provide the reward after the offeree has fulfilled the contract's requirements. Bilateral contract. It is an agreement when a promise is given in exchange for a mutual promise in return. With respect to the promise in issue, the party making the promise is the promisor and the other party is the promisee. The legal detriment incurred by the promisee consists of a different promise by him or her to do something or refrain from doing something that he or she was not previously legally obligated to do or to refrain from doing. This legal detriment constitutes consideration, the cost, motive, or benefit that induces one to enter into a contract. Express contract. It is an agreement where all elements of a contract are specifically stated, offer, acceptance, consideration, and the terms are stated. Implied contract. It is an agreement in which the existence of the contract is assumed by the circumstances to deny a contract would be unfair or in result to unjust enrichment to one of the parties. Quasi or implied in law contract. A contract imposed on both parties by the order of a court to avoid the unjust enrichment of a party in a dispute over a payment for a good or service to promote fairness and justice. In some cases, a party who has suffered a loss in business relationship may not be able to recover for the loss without evidence of a contract or some legally recognized agreement. To avoid this unjust result, courts create a fictitious agreement where no legal enforceable agreement exists. Formal contract or solemn contract. A formal contract is an agreement which the parties have signed under seal and recognized of the court, which is required by law for its efficacy to be in a certain specified form. It should have exceptions and general rules provided with the requisites. Informal contract or common contract. An informal contract is a contract which has no seal and refers to consensual contract. such as the contract of sale. An informal contract may be oral or written. Now, let us have the execution and validity of contracts, executed contracts. It is a contract that has been fully executed by both parties. Executory contract. It is a contract that has not been fully executed by one or more parties, or a performance which is not yet completed. Valid contract. A contract satisfying all the requisites in agreement of acceptance, consideration, legality, competence, and content of the contract. Void of contract or void contract. It is an agreement having no legal force or binding effect because of certain facts. It is considered as inexistent from the very beginning, which lack one or some of all of the elements, or do not comply with formalities which are essential for the existence of a contract. The expression void contract is a contradiction in terms. Voidable contract or annullable contract. A valid contract which possesses all the essential requisites, but one of the parties is incapable of giving consent, or consent is vitiated by mistake, violence, intimidation, undue influence, or fraud. Unenforceable contract are those that cannot be enforced in court or sued upon by reason of defects provided by law until and unless they are ratified according to law. Kinds of unenforceable contracts. Under Article 1403, the following contracts are unenforceable. Those entered into the name of another by one without or acting in excess of authority. Those that do not comply with the statute of frauds. Those where both parties are incapable of giving. Thank you very much, and God bless us all. That's all for today.